This is a Williamson Act contracts, and we'll get staff report to kick it off.
As you said, Mr. Chairman, Maury Anderson, County and Building Services. We are here today to consider several protests in regards to Williamson Act non-renewals that were filed by the county. The board will recall we worked hard to tune our guidelines and our rules and regulations for Williamson Act contracts. Pursuant to that, we worked with the assessor to establish contracts that were not substantially in compliance with the rules. So there's kind of two things working today. We have some of the non-renewals that were done by staff and by the county are either A, just not in compliance with the acreage requirements and the irrigation requirements, or B, have a conservation easement on top of the Williamson. A reminder, the county is only in a position to non-renew entire contracts. So what you're going to be hearing today are situations where part of the contract is overlaid by a conservation easement, and it's likely that some of the owners of the contracts will propose to go ahead and remove that portion but continue to be in a Williamson Act. We just don't have the option as the county to pick and choose portions of a contract. So each case is different. There's several of them. I want to turn it over to Galen Norwood, who's going to give you the fact set for each individual case, and then the county can consider any testimony from the contract owners, of which I see some here. I would propose that you maybe by a show of hands find out who's here, who came to visit, and go with them first. Any questions?
Is there a resolution in here, because maybe I missed it on some of them, where you can, to nullify the contract, non-renewal, and then take out the conservation easement and then re-up?
Yep.
With it? It's in there?
That's part of the options, and Galen's going to go through the recommendation, and with each recommendation, there's either something like that, or if it's complete in one case, we're opting after speaking with the assessor that our information wasn't right, and so we propose to cancel the non-renewal in its entirety. So each case is different. Galen will go over the specifics, and hopefully we can get through these relatively quickly. Okay.
Galen, I think Maury did a good job of the overview, and what I think the best way to do is when we call up, I'm just going to call up the contract holders in order of the agenda, and then that you give the particulars to each of the cases, because each case is a little bit different, and then you could start it off and take comments. So you'll have the ability for the contract holders. I'm going to call up each issue as specifically. So if you want to wait and comment at that time, you could do so, or any time. So the first one would be the Kramer Ranch. So item 4B.
Galen Norwood, Assistant Director of Planning and Building Services. So the Kramer was one of the 9 protests that we received out of the 44 non-renewals that were recorded in accordance with the resolution the board adopted last year. This particular contract, the conservation easement was on 341.9 acres of the contract. The remaining 4,067 acres meets the requirements in and of itself. So the Kramer's asked to just take the conservation portion that's in the conservation easement out and withdraw the notice on the remainder. In the packet is on page 11. It is a notice of partial withdrawal of notice of non-renewal consistent with the what was requested by the landowner, and it keeps the portion that's in the conservation easement in, takes the rest of it out.
How many acres of the 341 are in the conservation easement?
That is the total of it. Those are portions of, you'll note on there that we reference a warranty deed for the description of it, because there's a specific warranty deed for the conservation easement, so we accepted out the portion that's in the...
So 341 acres of
is
the
the total.
4,000 of the total contract is what you're...
4,067 acres in the remain.
That's what I was looking at, when is that number?
Okay.
if I might, it's 3,651 acres. You don't need to add that back in. Total contract acres, meaning Williamson Act contract, 3,651.66 acres. For the record, this is Kenneth Bunch, Lassen County Assessor. And there's about 10% of it. The 341 is what they can serve.
That's different to the staff report, but there's a substantial.
Well, you were saying 4,000, I was correct.
Yeah. Okay, thank you. So, we'll turn it over to the public. Is anyone from the public that would like to talk on the item 4D, the Kramer Ranch? Seeing none, we'll bring it back to the board, and the contract holder is looking for board approval to concur with their protest, that they would like the balance of the ranch to remain in the Williamson Act.
So this is the notice of the partial withdrawal is what we're acting on?
Yeah, and we need to either approve or deny their
It's 4B. The agenda spells it out, so for the action is determine that the nominal was appropriate and leave it like it is, or determine, direct staff to record a notice of withdrawal, the notice of nominal, accepting the portion that is in the conservation easement.
So we're actually looking at B versus A.
4B.
4B. Yeah. Is that your action?
That's my motion.
That's your motion, I'll second it.
Okay, we have a first and a second. All those in favor, say aye.
Aye.
The chair votes aye. The motion passes unanimously. We'll move on to item D5. Surly Farms.
Yes, Meserly Farms. Mr. Meserly submitted a protest of the notice of non-renewal. He has, claims that he has 97 acres irrigated. This was one that was non-renewed because it did not meet the acreage requirements in the resolution adopted by the board last year. So, you know, the question for the board here is that close enough? You know, he has 97 acres of irrigated land, not the 100, but he is, by all accounts, you know, engaged in producing on that.
Thank you. Supervisor Lovell?
So, of the 100 acres, he's 97 of it's irrigated. Is the other 3 acres, is that where the house sits and his equipment yard and his barns, et cetera? Is that part of the?
Correct, that's my understanding. And the board, in the resolution that it was adopted last year, the board said it needs to actually have 100 acres that's irrigated, so not the home site that didn't count. And so that's why it's here on this list, is because he has 100 acres, but he only has 97 acres of irrigation, whereas the resolution calls for 100 acres actually irrigated.
Kenneth Bunch, Lassen County Assessor. Miserly property does have an adequate irrigation system for over 100 acres. He is also leasing some adjacent ground that was Williamson Act. It's currently in the non-renewal process due to the size of the parcels. The resolution that you passed does give you some leeway on this, and I would encourage you to allow Mr. Miserly to stay in the program.
Thank you. Is there any members?
Well, I just have a question, okay? I appreciate, you know, the standards that are set by the law and the conditions, and we kind of, you know, arbitrarily, I guess, last year and over the years have debated that. So if 97 is close enough to 100, is 95 close enough to 100? I mean, at what point do we start shaving off and draw that line? Now, I had no problem with the 97. But at some point, there's gonna be rock bottom. Pretty soon, 97, well, the guy that's 93 now is close to 97, so then it keeps dropping. And see, and that was the problem that this program got into from the get-go. Because when the staff used it to leverage getting subvention monies from the state, you know, they threw in every Tom, Dick, and Harry, and we had people that didn't even come close to meeting what the qualifications and the needs of the program is defined originally by state law. So that was the debate that culminated last year when we set, what those minimum standards are. So I have no problem, but I just have to say, at what point does the next guy that comes through say, well, you gave that guy 97, I've got 85, I'm substantially close to 100, but, not close enough. I mean, where do you draw that line?
I think, May, when we set the criteria, we also made it, we did say that we realized some specific contracts might not meet the criteria, but they'll be part of a bigger overall farming operation. And as the assessor pointed out, that seems to be the case. This particular farmer does have agricultural operations outside of this contract. Also,
And he also is making an effort with this particular parcel to farm it year in and year out. It's not just an occasional thing, not a hobby farm.
But I understand perfectly what you're saying. In the letter submitted dated 19th of November, he does make it clear that agriculture is his main income. And by all, I'm satisfied that he's.
Well, I'm satisfied too, but I just want to make sure
Right.
that what happens is this is exactly the path the staff and the board got into years ago that took a program that was meant for big, and we had everything under the sun included.
No, and that's a good point, and I thought of the same thing. If you go 97, then it's 96, and 92, and so on and so forth. But in any case, let's go ahead, state your name for the recorder, please.
Craig Hemphill, Lassen County Ag Department. This property of Rudy Misery's that's in question used to belong to Bob Hirschberger. And Bob Hirschberger had built the house that Rudy now lives in, plus his own residence, plus a residence for his son, which he obviously probably parceled off. I don't know this for a fact, but the ranch was at one time bigger than it currently is. And he obviously built some residences there to live in. So at once upon a time, it did meet the acre requirement, but over a period of time, it got dwindled down to 97 irrigated acres. So that's the history of it. That's why it is below standard.
Okay, thanks. Anyone else from the public like to comment on item 5D? Seeing no.
I would, Mr. Chairman, make a motion that we follow item 4B, and that we find that the subject contract substantially complies with Lassen County Rules and Act policies and procedures. Direct staff to record a notice of withdrawal of the notice of non-renewal. I just want to state for the record that at some point in time, after this gentleman has done it, his successor decides not to farm it, and it just sits there kind of fallow most of the time, or it becomes like an occasional thing. That doesn't preclude the county from coming back with a non-renewal in the future. But I think given his testimony and the respect for it, I can live with keeping this one in the program.
Thanks for adding that, that's a good point.
Yeah.
Okay, we have a motion. We have looking for a second. Okay, we have a first and a second. All those in favor, say aye. Aye. Chair votes aye, the motion passes unanimously. That'll move us to item D6, the Whipple again.
Yes. So the conservation easement, this one was not renewed because it was on the list that had a conservation easement that was provided. This was provided by the assessor. It was non-renewed. He's protested. The conservation easement affects 39 acres, and Mr. Wimble purports that the remaining 2,160.36, this is the acres I have, meets the requirements to be in the program. And so the action for the board is to determine that the non-renewal is appropriate and leave it alone, or direct staff to record a notice of non-renewal, notice of withdrawal of the notice of non-renewal, accepting, as requested by the landowner, the lands included in the conservation easement.
Thank you. Anyone from the public would like to speak?
Ken Whipple. And I'd like to for you to consider, pulling it out of the non-renewal and continue, but this is part of a whole program, Spring and fall is very important to run on 400 or 500 cows. You gotta have somewhere to go with them. So It is ground that, you know, takes 25, 30 acres to a cow, but it's still essential to the total program moving forward.
Thank you.
Mr. Chairman, I'd like to make a motion that we proceed with item 4B, direct staff to record a notice of withdrawal of the notice of non-renewal accepting as requested by the landowner the lands included in the conservation easement.
We have a first and a second. All those in favor say aye.
Aye.
Chair votes aye. Passes unanimously. Before we move on, I just want to say one thing that I really appreciate. I know it's a pain for the contract holders to have to come here again, but this is just one of the necessary steps. I mean, into cleaning up this Williamson Act and getting the program manageable and making sure that those who still do have a contract, especially with the absence of the state subvention funding, that those contract holders are legitimate agricultural concerns. And we're just about there. This is one of the last pieces of business, and I truly appreciate the effort on the part of the contract holders to assist, and the county staff and the assessor and all those involved to clean it up. We've done a lot in the last couple of years, and it's encouraging. So with that, we'll move on to item 7B, the Darrell and Kelly Wood.
So there are several different configurations and individuals that own property for wood. This one is the Darrell and Callie Wood Family 2005 Revocable Trust. And so this is identified as a separate contract from the others because it has a unique ownership. And the conservation easement affects 222.26 acres. 160 acres left needs irrigation to satisfy policy 1H of resolution 12050. That's on page 11 of this packet, or page 4 of the policies. So on page 6, the assessor asserts that there is not adequate irrigation, and therefore, without adequate irrigation on this remaining 160 acres, it does not meet the standards that Lassen County has. So therefore, that's why the policies, you'll note that there's not a B there, just because with the information we have, unless new information is submitted here, there is not irrigation on the remaining 160 acres, and it doesn't meet the standards. So they're consistent with the policies. There's no option but to keep their nominal.
I have a question for you. Do you have any knowledge as to the relationship between of this 160 acres to the 1,988 acres, the same trust farms in item 9D?
Yeah, the trust owns a portion of that item, but the other owners own it as well, and so therefore, consistent with the policies that the board adopted last year, it's considered a separate ownership. So for purposes of the contract goes back to who's owning it, and this particular contract is owned by Darrell and Callie Wood, 2005 Revocable Trust, while on the others, this trust may be a portion of the ownership. It's not the entirety of the ownership. Other individuals own as well. So therefore, they're treated differently. As far as the activities on the ranch, I couldn't speak to that.
Okay, thank you. With that, we'll take public comment. Would anybody like to comment on item 7B?
Good morning. My name is Darrell Wood, one of the owners of the Darrell and Callie Wood Family Trust and partners in various other entities in Lassen County. I have some confusion on that 160 acres, which I talked to the assessor Ken Bush on. To our knowledge, the 160 acres is a standalone piece of ground. It's not part of another parcel. And it's below Peaks Valley Ranch, which is another entity. And this ranch adjoins our BLM, where we use it as a gathering source to come into off of the public lands in the fall. So I don't know if we need to get clarification on that, Ken, or not at this point.
Yeah.
I'm glad to speak to that. Kenneth Bunch, Lassen County Assessor. Basically, our records showed that the Wood Trust, not in combination with other family members, would own 100% of 382 acres. Darrell here has said that he thinks that maybe only that 160 is owned independently, but regardless, it still is less than the 400 acre minimum that the resolution had set. And even if you add it to all these other related entities other than Wood Cattle Ranch, which has different members to it, you still have that 160 that stands alone without a contract. Because so many of the other ones are 100% encumbered by I shouldn't say contract, an easement. The other ones are 100% encumbered by a conservation easement. So if you put the Wood Trust and children and Darrell and his wife as a unit, you still have 160 acres that stands out there without a contract, but smaller than our minimum of 400 acres. Without the 100 acre irrigated, it doesn't meet the 100 acre irrigated.
So, sorry, Ken, so 7D, the relationship between 7D and 9D doesn't, though there's different people, I think. I just follow up on Galen.
Well, could you give me the names instead of the 70 and
Yeah, well, they're both Darrell Wood.
Right, I mean, it's okay with Darrell, I don't think it's a secret.
It's
you
the
know.
Wood Cattle Ranch.
Wood Cattle
Oh, Wood Cattle Ranch.
Yes.
The Wood Cattle Ranch would be Darrell and his two siblings without spouses. Wood Trust is Darrell and his wife, and they have partnerships with the trust and Darrell and himself, and the trust and Darrell and his two children, all as separate, unique legal ownerships as per the resolution adopted last fall.
Okay, thank you. Is there anyone else who would like to speak on this item? The pleasure of the board.
I would move, Mr. Chairman, that we go with 4, find that the contract does not meet the acreage requirements of Lassen County Williamson Act Policy, Section 1H, and determine that the recorded non-renewal notice is appropriate.
I'll second.
Okay, we have a first and a second. We'll call for the vote. All those in favor signify by saying aye. Aye. Chair votes aye, so passes unanimously. With that, we'll move on to 8D.
Just gonna check to make sure I'm matching up here. This is for the Darrell and Callie Wood and Darrell and Callie Wood 2005 Revocable Trust. And so the situation here is that the conservation easement affects all 483.5 acres of this contract. Therefore, the contract can't comply with the acreage requirements because you will call or excludes the conservation easement. So therefore, it has no land in it remaining. So this is one to where there is not an option B, if you will. There's just consistent with the policies. It doesn't meet the acreage requirements.
Thank you. Anyone from the public like to speak on this?
Darrell Wood again. So at this point, we've got several other applications coming up, so I think it's important I lay some background for you folks. My family and I, we've been ranching in Lassen County since 1860. I'm the 6th generation, my sister and brother. My daughter Dallas back there is the 7th, and Carrie, my grandchild, her child, is the 8th generation in Lassen County. I think that pretty well supports our commitment to ranching and agriculture in Lassen County all the way through for almost 150 years. I also want to applaud the board for its support of the Williamson Act, because essentially no new information here, but it values the ground from a tax standpoint based on what its use is and not what its highest potential use is, which back in the old days it could have been next to a subdivision and been taxed accordingly. So it causes the tax base to be based on what is produced on the property, and I think that's great. My family, we've taken a step further, knowing that there's some challenges to Williamson Act. There's another tool available for ranching that's called agricultural conservation easements. And what these easements do, to simplify things, is that it's a real estate contract that has all the points of law just like any other real estate transaction. You have compensation, you have a legal description, you have restrictions, you have usage, you have all this stuff. And so what we did is we put conservation easements, agricultural conservation easements, on all our properties. The funding mechanism for all these properties was from public money. Well, you ask yourself, why would public monies be involved in agricultural easement process? Well, up at Horse Lake, Pete's Valley, those two pieces of ground are primary breeding ground and stomping grounds for the sage grouse, which was discussed earlier, is on petition to go on the endangered species list. So the USDA and RCS felt it was important enough to protect those landscapes to be able to lend support to these birds, so we can do restoration improvements to be able to enhance the birds themselves, to be able to keep populating. Now over in Johnsonville, public monies were used there as well, and the money was supplied by the California Wildlife Board in Sacramento. Reason that they were interested in that piece of ground is because it borders the Bass Hill Wildlife Preserve. They were not interested in seeing subdivision, urban use spread up to that wildlife preserve, so they were interested in funding the conservation easement on our ground that acts as a buffer between that. Not only because it's next to the wildlife preserve, but it's also a major waterfowl migratory area where when we have water, those birds that land and rest, either going down to the winter ground or coming back up to the summer ground, they would land there and rest and or nest or both. And you know, the other thing I want to commend the board was on the resolution 12-050, where it states, and to paraphrase, that the county and the Board of Supervisors strongly supports agriculture. And it goes on to list A through B, its mission statements of supporting agriculture. One of them being, agriculture production is and will remain a principal land use in Lassen County. B, agriculture production on land within Lassen County constitutes an important social, physical, aesthetic, and economic asset to the county. And then C, in addition to range of economic importance of commodities or agricultural land, provides open space, scenic values, wildlife habitat, and land stewardship, and contributes significantly to the county's rural character. Properties which are not in compliance with the Act or contract provisions jeopardize the viability of this program within the county. So I think that's a great statement you guys made there. But I would like to take it one step further. The Williamson Act contract is only for 10 years. That means that tomorrow you can cancel it. 10 years from now, that land no longer is going to be protected under the Ag Preserve, and so the landowner can then, petition it for subdivision or whatever he wants to do. When we put an agricultural easement on a piece of ground, we endorse all of these values that you listed on here, plus the fact that that land will be an easement process in perpetuity, which is forever. Now, I said earlier that this is a real estate contract. So each and every one of them is going to be different. So I would suggest to Ken Bunch from the assessor's office and you gentlemen that when one of these applications comes up, that you should get a copy of the easement application, read it, understand it, and make sure that it doesn't subscribe to the principles that you guys have here, because not all easements are the same. Now, on our conservation easement, the only thing you can do on it is raise cattle, you can hay it, you can grow crops, you can use it for a confined animal operation. There's no restrictions except for subdivision. So, in my mind, I think that the restrictions on the Williamson Act and the restrictions on the conservation easement are similar. Therefore, when the assessing process comes to being whatever that is, the values are going to be the same, or pretty close. You know, I'm a civil man. I don't know all these things in detail, but that's just common sense to me. So I have to ask the question, if they're going to be pretty similar in value when the dust settles or, you know, comes out of the laundromat, why would the county want to take away a tool that would allow it to have additional income off this property? And that is